Did you know that 60% of UK adults don't have a will or a lasting power of attorney? Your family could face up to a cost of £2,000 plus in a court battle just to manage your finances after you've gone, or even if you lose capacity. Today we're revealing 5 critical mistakes that could leave your loved ones in a legal limbo. I'll also show you ways to avoid them. Welcome again to Peace Unplugged. I'm your host Martin. Today we're tackling 2 of the most important documents in your life. These documents you need to create as soon as possible. That is your will and your lasting power of attorney. They're not just your pieces of paper, they're your voice when you can no longer speak. They'll be your wishes when you can't express them. And they're also the protection for the people you love the most. Yet amazingly, people across the UK are living without wills. Most people assume they don't have the time to get this created, or they think the process of doing so is just far too complicated. Now, frankly, I've got some experience of the complications caused and the stress involved with extended family when parents finally pass away. It's an issue I thought would never happen to me and my family. But sadly, it's all too common to split with the extended family, and these splits happen particularly when there's an inheritance involved. My experience was stressful and it was complicated, but it could easily have been much, much worse. I've now made the decision to make sure this is okay for my own family, for the time when I'll eventually pass away. Believe me, it's incredibly important to do this for peace of mind. By the end of this episode, you'll understand exactly what you need and also why you need it, and how to get it right first time. Through research, I've learned that everybody's circumstances are different. So getting some legal advice for individual circumstances is absolutely paramount. Okay, so now I'm going to share with you some scenarios, and these are based on real-time examples. Let's start with number 1, the will disaster. When good intentions meet bad documentation. I'm going to introduce you to Sarah. She's a 52-year-old teacher from Manchester. She had a will and she'd written it herself. She did so using a template, and that was 10 years ago. She felt responsible and she felt prepared. She had 2 children from her first marriage and had recently remarried. When she passed away unexpectedly, her family discovered her DIY will. They didn't rank on it tearing them apart. So where was the problem then? Sarah's homemade will didn't account for her remarriage. Under Section 18 of the Wills Act 1837, marriage automatically revokes any previous will unless the will was made in contemplation of that marriage. Sarah's wasn't. This meant she died intestate, without a valid will. Under the intestacy rules set out in the Administration of Estates Act 1925, as amended, her new husband was entitled to the first £322,000 of her estate, plus half of the remainder. Her children from her first marriage watched as their childhood home, worth £450,000, would need to be sold or refinanced, with their stepfather receiving the lion's share. The family ended up in a bitter dispute. It cost them over £30,000 in legal fees, and sadly it destroyed relationships that had been cordial before. A real example of this is documented in cases like Marley versus Rawlings 2014, UK SC 51, where the Supreme Court had to intervene in a will dispute that could have been avoided with proper legal drafting. So here's a solution to this complication. First, understand that marriage, divorce and civil partnerships all affect your will. I can't emphasise this enough. It is vitally important that you review your will and update it after any major life events. Secondly, use proper legal execution. Your will must be signed in the presence of 2 independent witnesses, and they must not be beneficiaries. That's according to the Wills Act 1837, Section 9. Thirdly, consider using a solicitor for complex estates. The Law Society estimates this cost is between £150 to £500, but it could save your family tens of thousands of pounds. So here's the key action to take. Review your will every 3 to 5 years, or after marriage, or divorce, or birth of children, or if significant assets change. Here comes the second example, the capacity crisis. Why you need a lasting power of attorney before you need it. Meet David, a 68-year-old retired accountant from Bristol. He'd always been meticulous with money. He managed his own investments and property portfolio, and they were worth over £800,000. Then suddenly he had a stroke. Within 48 hours, he'd lost the ability to communicate effectively. His wife Jane needed access to the joint savings in order for him to have some private care, but the accounts required both signatures. Their solicitor explained they had no lasting power of attorney in place. Without an LPA, Jane had to apply to the Court of Protection for a deputyship order. That application took over 7 months at a cost of £2,400. That was the court and legal fees. There was also an annual supervision fee of £320. During that time, household bills went unpaid, investment opportunities were missed, and Jane had to borrow money from their daughter to cover the care home costs. This reflects the reality confirmed in CC versus KK and STCC 2012 EWHC 2136 COP, where the court emphasised that once someone lacks mental capacity, defined by the Mental Capacity Act of 2005, no one, not even a spouse, can automatically make decisions on their behalf without legal authority. The Court of Protection receives over 24,000 applications annually for deputyship orders, applications that could have been avoided with an LPA, costing just £82 per application, or £164 for both types. So here's what you need. There are 2 types of LPA in the UK. The Property and Financial Affairs LPA, that lets your attorney manage your money and your property and your financial matters. The Health and Welfare LPA allows your attorney to make decisions about medical treatment and care. You must have mental capacity when you create an LPA. You cannot create one after you've lost capacity. The Office of Public Guardian processes these, and they must be registered to be valid. That's the Mental Capacity Act 2005, options 9 to 14. The process takes 8 to 10 weeks, and it costs £82 per LPA if you register online. Choose your attorneys carefully. They should be trustworthy, financially responsible, and willing to act in your best interests. You can appoint multiple attorneys to act jointly, that is jointly and severally, or with specific conditions. So here's the action to take. Create both types of LPA as soon as possible, ideally before age 50, and certainly before any signs of declining health. Now let's look at scenario number 3, the blended family nightmare. This is where estate planning gets really complicated. Patricia and Robert were in their late 60s. They've both got adult children from previous marriages. They've been happily married for 15 years. They owned their £600,000 house jointly. Patricia assumed that if she died first, everything would automatically go to her husband, Robert, and then eventually to her children. Robert had the same assumption about his children. Neither of them had made a will because they thought it would all just be very straightforward. When Patricia died, Robert inherited the jointly owned home through right of survivorship, not through her will, which actually didn't exist, but through how the property was legally held. Here's what Patricia didn't realise. Robert was now free to change his will and leave everything to his children. That was completely disinheriting Patricia's children. 2 years later, Robert remarried. Under intestacy rules, his new wife would now be entitled to the first £322,000 of his estate. Now, Patricia's children, who assumed they'd received something from their mother's contribution to the home, were effectively left with nothing. This scenario reflects the principles examined in ILOT versus the Blue Cross and others, 2017 UKSC 17, where the Supreme Court addressed claims under the Inheritance Provision for Family and Dependents Act 1975. The court emphasised that adult children have limited rights to challenge an estate distribution unless they can prove dependency. So blended families need sophisticated estate planning. Consider these solutions. First, you can use a life interest trust. That's also called a right to occupy trust in your will. This allows your spouse to live in the property for their own lifetime, and it also ensures that it passes to your children after they die. This was endorsed in Re Eaton 1964, 3 ALL ER 229. Second, consider holding your property as tenants in common rather than joint tenants. This means that each person owns a distinct share that could be left to anybody in their will, rather than just automatically passing to the survivor. Thirdly, include a letter of wishes with your will explaining your intentions. While it's not legally binding, it provides some moral guidance to executors, and it can help prevent disputes. Fourth, discuss your plans with all your family members. Research for Resolution, the family law organisation. This shows that transparency reduces inheritance disputes by over 70%. Here's a key action. If you're in a second marriage and have stepchildren, seek legal advice on protective trusts and property ownership structures. Now let's look at example number 4, the business owner's blind spot, protecting your commercial legacy. James built his manufacturing business over 30 years from scratch. He employed 40 people, and his business was valued at $2 million. He owned 60% of the shares. His business partner owned the remaining 40%. James had a will, leaving everything to his wife and children. He thought this would allow them to benefit from his life's work. Sadly, James died unexpectedly at age 61. Then his family discovered several problems. Firstly, inheriting all the shares triggered a £400,000 inheritance tax bill, and that was deemed to be payable within 6 months. His wife didn't have the cash, and the business couldn't pay dividends, certainly not large enough to cover it, without jeopardising operations. Secondly, the business partnership contained a clause that required shares to be offered to the existing partner first, and that at a price determined by a formula that significantly undervalued them. James's family was forced to sell at a loss. Thirdly, James's family knew nothing about running the business. Under the Companies Act 2006, they inherited the shares but had no authority to act as directors. The business partner now effectively controlled the company, whilst James' family held majority shares they couldn't sell and couldn't use. This mirrors issues raised in Re Sharp 1980, 1 WLR 219, where the court addressed the complexity of business assets in estates. Business owners need specialised estate planning. First, arrange business property relief. BPR. Trading businesses can qualify for 100% of inheritance tax relief if they're owned at least 2 years before a death. This is outlined in the Inheritance Tax Act of 1984. Section 104. You need to ensure your business structure qualifies. Second, set up a business trust or arrange life assurance in trust to cover any tax liabilities. A £500,000 life assurance policy in trust can be paid directly to beneficiaries without forming part of your estate. Thirdly, create a comprehensive shareholders agreement or partnership agreement that addresses death, incapacity and succession. Include buy-sell provisions funded by life insurance. Fourthly, establish an LPA specifically for business affairs. Appoint somebody with commercial experience who can step in immediately. Consider enterprise management incentives, or EMIs, or gradual ownership transfer to family members during your lifetime. These can be more tax efficient than inheritance. So here's the key action. Business owners should conduct an annual estate planning review with both solicitors and accountant specialising in business succession. Now let's look at scenario number 5. This is the digital age dilemma. This is modern assets and medical decisions. Emma was 44, single and tech savvy. She got significant cryptocurrency holdings and they were worth £150,000. She got income from 3 websites, digital photo libraries, social media accounts with professional value, and email accounts containing important documents. She'd also registered as an organ donor, and she had very strong views about end-of-life care. She assumed that her brother would be able to handle everything, if something happened to her. Unfortunately, a serious car accident left her in a coma. Her family faced multiple crises. They couldn't access her cryptocurrency wallets. The private keys were stored on her laptop, which was also encrypted. Then her website started failing. There was no payment for the hosting. The incomes stopped flowing. Facebook and Google would not give her brother access. It would take a complex legal process, and that took months. More critically, Emma never discussed her medical wishes, at least not in any detail. Doctors needed a consent for risky surgery. Her brother thought she'd be kept alive at all costs, but the problem was her best friend insisted that she told her she did not want to be kept alive on life support, should that come about. Without a health and welfare LPA, the family faced an agonising court battle, while Emma remained in limbo. The Data Protection Act 2018 and the UK GDPR make it legally difficult for family members to access digital accounts without explicit authorisation. This reflects issues raised in cases involving digital assets, where courts have had to navigate between privacy rights and estate administration. Modern estate planning must address digital and medical complexities. For digital assets, first, create a digital asset inventory listing all accounts, websites, cryptocurrency wallets, and where access information is stored. Second, explicitly authorize your LPA attorney or executor to access digital assets. Include this in your LPA application in the additional instructions section. Third, consider using a password manager with emergency access features that allow your attorney to gain access after a waiting period. For medical decisions, create a detailed health and welfare LPA that specifies who should make medical decisions if you lack capacity, your preference for life-sustaining treatment, your wishes regarding any organ donation, whether you want to be cared for at home or in a facility, and your views on experimental treatments. Include an advanced decision that used to be called a living will. Under sections 24 to 26 of the Mental Capacity Act 2005, this can refuse specific medical treatment in specific circumstances. For example, refusing artificial ventilation if you're in a permanent vegetative state. So here's the key actions. Review the Mental Capacity Act Code of Practice. Create a comprehensive digital assets list. Have detailed conversations with your health and welfare attorney about your medical preferences. So in summary, let's look at 5 essential solutions. Solution number 1, create a legally valid will. Use professional legal help for complex estates and what's called blended families. Ensure proper execution with 2 independent witnesses. Review and update this every 3 to 5 years and after any major life events. This costs about £150 to £500 for solicitor drafting, but it's actually priceless peace of mind. Solution number 2, register both types of lasting power of attorney. That is property and financial affairs LPA for money and assets, a health and welfare LPA, that's for medical and care decisions. Register whilst you still have capacity. Don't wait until it's too late. The cost is £82 per LPA, and it saves thousands in court protection fees. Solution number 3, address complex family structures. Use protective trusts for blended families. Consider property ownership structures carefully. Include clear instructions and letters of wishes. Communicate your plans to avoid future disputes. Solution number 4, protect business assets and commercial interests. Arrange business property relief for inheritance tax. Create comprehensive shareholder agreements. Use life insurance in trust for tax liabilities. Appoint attorneys with commercial experience. And solution number 5, plan for digital assets and medical wishes. Create a digital asset inventory. Include access instructions. Authorize your attorney to access those digital accounts. Create an advanced decision for medical treatment preferences. Have detailed conversations about end-of-life wishes. Estate planning isn't about death. It's about protecting life. It's about making sure your family's cared for, making sure your wishes are respected, and that your life's work doesn't lead to legal complications. Again, don't wait until it's too late. The Law Society can help you. Find a qualified solicitor that specialises in wills and probate. The Office of the Public Guardian provides free guidance on lasting power of attorney. Age UK offers excellent resources for estate planning at any age. Take some action this week. Have that conversation with your family. Make the appointment with the solicitor. You can create an LPA online, apparently, at gov.uk/lasting-power-attorney-duties. Your future self and your family will thank you. Now, I'm aware that this podcast may not answer all your questions. It is a kind of general guide, and I know you may have more questions. Please leave some of those questions in the comments below on the YouTube podcast page. My plan is to do a follow-up podcast with a guest who is a professional in wills, estate planning, and lasting power of attorney. Share this podcast with your friends, as well as extended family. It really is just so important. In the meantime, access your personal peace and keep well. Bye for now.